So thanks everybody for joining us for the webinar today. Again, I am Mike Monteforte, and our topic today is estate planning for modern families, specifically estate planning strategies for blended families and estate planning after divorce. I'm going to ask everybody to make sure you stay to the end of the presentation today because we do have a special offer for our seminar attendees. And we'll talk more about that towards the end of the presentation, but all of our viewers that join the webinar today receive a free strategic planning session with me to talk one-on-one about your planning, and anybody that attends the webinar and hires our firm does receive a $500 discount on your estate plan. So make sure you stay to the end to get the details on those offers. And so real quick, what are we going to do today? Our agenda is to start with a real client example. We're going to start talking about a client of mine, a real client from a couple of years ago that had a blended family, and we're going to talk about the many, many things that went awry in that case because this client of mine didn't have any planning when he passed away. We're going to talk about ways that we can help you, ways that we can prevent those bad things from happening. We're going to hit quickly on what's called the Massachusetts Parentage Act. It's a recently updated law that, in my opinion, makes no sense whatsoever, but we're going to talk about that because it is a law that's on the books that affects blended families in what I feel is a very negative way. And we want to make sure that we complete our planning so that that act, that law, that Parentage Act doesn't affect us in a negative way. If we don't do any planning, it can really hit us hard, but with planning, we can get around it. We're going to talk about why and how we plan, and we're going to talk about making our clients, the parents in these blended families, the hero in this situation, because they are giving, it really is estate planning. It's a gift that you're giving to your family. If something happens to you and you become disabled or you were to pass away, we don't want to leave a mess for our families to have to clean up. It's one of the biggest things that I hear every day meeting clients. I don't want to leave a mess for my kids. I've been through that maybe with my own parents or family and seen how horrible it is. I don't want to leave a mess for my kids. Well, we're going to talk to you about how to make sure that doesn't happen. So real quick question for everybody, yes or no. Have you already started your estate planning? Do you have some form of estate planning, whether it's a will or a trust? Maybe you have a power of attorney or a healthcare proxy. So when you see that poll pop up, you can click yes or no, whether you've got any planning in place at this point. I'll tell you, if you do have something in place, you're ahead of the game. So kudos to you for anybody that does have some planning. So let's talk about the lack of a plan. What happens if we don't have a plan? If we don't do an estate plan that deals with our disability or even our eventual passing, what happens? If we haven't made those decisions for ourselves, stating what we want, well, at that point, the Commonwealth of Massachusetts or whatever state you live in has an estate plan all ready for you, and Commonwealth of Massachusetts has decided who's going to get what and how much. So Commonwealth of Massachusetts is going to have that all set and ready to go in place. And there's a plan that most people, when they look at it, realize it's a plan that they don't like. Okay, so let's talk a little bit more about what happened. So I had a client of mine. His name was Dave. Good client of mine, became a friend. Originally came to see me about doing planning for his mom. And then partway through, we started talking about doing his own estate planning. And while we were in that process, we decided that, we were going to back burner his planning because he was really concerned about getting his mom's planning done first. And Dave had a blended family. He was married once. He had two kids. They were in their 20s, got married again, and had a child with his second wife, who he was still married to. She was very young. She was about 3 years old at the time. And Dave's second marriage was on the rocks as well. So he was on his way to divorce number two. Well, before we could do any planning for him, Dave died suddenly. Passed away from a heart attack. He wasn't sick. He had no indication of anything going wrong, no indication of any illnesses or anything like that. And he passed away actually on Father's Day weekend, and his older kids found him on his couch. Well, like I said, Dave had no planning. Two kids from marriage number one in their 20s, one young child from marriage number two. Well, because he had no plan in place, everything that he had went to his wife. Dave was a blue collar guy, but he worked for the same company for almost 40 years. He had a nice retirement through them, nice life insurance policy through them. Well, everything went to his then wife, and she decided that she wasn't going to give the children from his previous marriage a dime. She was going to keep everything for the child that she and Dave had together, and she was going to completely exclude the two older kids from marriage number one. And they got nothing. They called me, Mike, is there anything we can do? This isn't what our dad wanted. He wanted all of us to share equally. He wanted us to split between the three of us. Plus, he was on his way to divorcing wife number two. Why should she get everything? Well, unfortunately, because the law says so, since Dave had no plan, she was able to completely cut out the kids, and they didn't get a dime. I tried to call her to appeal to her sensibilities as a person, and she couldn't have cared less what I had to say. And the children from marriage number one got absolutely nothing, which was exactly what our client did not want. All right, so it looks like we're around half and half as far as folks that have planning versus folks that don't have any planning at this point. So again, those of you that do have some planning, kudos for you. Kudos to you for being ahead of the game. For anybody that doesn't have any planning, you are not alone. Everybody procrastinates with this stuff, and that's why we're here. So what could we have done for Dave? Well, we could have done a trust that made sure his kids got their share. It would have made certain that all of the kids shared equally in his estate. He could have put those funds into trust, made sure that those assets were protected for the kids. So whatever he left them, we could have protected it through our hindsight trust, protected it from their own divorces if they got married and divorced, or if they had bills, credit cards, school loans, other liabilities. We could use our very specific proprietary trust to make sure that not only did all the kids share, but that each of their shares was protected from whatever was going on in their lives. So again, if they got married and then got divorced themselves, we wouldn't want that divorcing spouse to be able to walk away with a share of the inheritance from their father. And with the proper trust, we could have prevented that. So another poll question that we're going to put up, and this is a two-parter. This is a true or false question. What I want to ask the audience here is whether or not you're aware of, number one, are legally adopted kids considered your kids under the law, and are stepkids legally considered your kids under the law? So we'll launch that poll, and then we'll launch the results of that afterwards. But so if anybody in the audience wants to take a guess, there are our adopted kids legally your kids, and our stepkids legally your kids, and we're gonna talk about that in just a moment. All right, people are answering now, and it looks like folks are correct on the adopted side of things. Our adopted kids legally your kids, and then we're about half and half on the stepkids. So we'll talk about that right now. If you remember at the beginning, I mentioned the Massachusetts Parentage Act, and this was a law in Massachusetts that was recently revised. In my opinion, the law was revised in a bad way. They had an opportunity to fix something here, and they did not do it. Our legislature, in my opinion, failed again, because Massachusetts law excludes stepchildren from the legal definition of the phrase my children. Even if you raised them, even if you're their step parent from when they were a baby and you raised them all the way up until they're adults, and you're, the only parent that that kid ever had, the legal definition of my children does not include stepkids under this Parentage Act. Stepchildren must be named explicitly in your estate plan. Legally adopted kids are included in that term, my children, but stepkids are not. So even if you have a will or you have a trust and you say, I leave everything to my children in equal shares, even if you intended for your stepchildren to be included in that, under the law, they would not be. If all you used was the phrase my children and you didn't list out each child, including the stepkids, one at a time, your stepkids would be excluded under this Parentage Act. So if, for those of you that do have a will or trust already, if you do have stepkids, take a look at your documents and make sure they're specifically named, because if they are not, they are excluded. And again, Massachusetts had an opportunity to fix this when they revised this Massachusetts Parentage Act, and they did not do so. So, in my opinion, they got this wrong, and they definitely screwed this up as far as I'm concerned. And again, did a disservice to the families of Massachusetts. So, let's talk about the top three post-divorce planning mistakes. Divorce has an effect on your already existing estate plan. In the past, divorce didn't do anything to your estate plan, and then they changed that rule some years ago because they said, well, we want to give a way for divorce to automatically remove our exes from our estate plan because people forget to do it, and so we want to automatically remove them. So under the law, even if you have a will or a trust that leaves assets to your ex, and you forget to change it and you get divorced, the law says, okay, we're gonna treat those exes as if they predeceased you. Well, that is very problematic. It does not solve the problem. We'll talk a little bit more about how we solve the problem, but just the act of those provisions being removed, it doesn't help anything. So, number one, post-divorce planning mistake is failing to update your beneficiaries. When we're talking about life insurance policies or bank accounts or investment accounts, and we name our beneficiaries on those accounts, well, technically those assets are not part of our probate estate. And if we don't update them after the divorce, those assets can go to the wrong people. I see it all the time. So that's number one, biggest mistake. Number two, no trusts for minor children. All right. If we've got kids under 18 and we're leaving them money and something happens to us, number one, their guardian is going to have control of that money. And typically, who's the guardian? Our ex-spouse. So if you get divorced, you pass away, you leave your kids money, and you don't do it in a trust, guess who's got control of that money? Your ex-spouse does, and they can do whatever they want with it with no oversight. So not only can they go on vacation, but they can take their new boyfriend, girlfriend, husband, or wife with them on your dime, and there's nothing you can do about it. However, we can prevent that by using a trust. Mistake number three, not designating guardians and trustees in your plan or having no plan whatsoever that would designate these things to make sure that someone is going to be in charge of the money, especially if you have young kids, and in most cases, making sure that that person is not our ex. There are some rare cases where folks are okay with their exes controlling the money, but I'll say that that's in a very, very minority of cases. Most of the time, we don't want our exes in charge of our money when we pass, and the way we get around that is by naming trustees to control the money for our kids when they're young. So again, real risk here, and we see it every day. Your ex could end up controlling your money through being a guardian for your kids. If your child is under 18, ex-spouse becomes guardian, they're in charge of the cash if you don't have a trust. If we have a trust, we can choose someone that we want to go ahead and be in charge of the money, make sure that it's used solely for our kids' benefit, and making sure that they've got what they need without giving our ex the ability to completely control the purse strings with no oversight and no restrictions on how that money is used. Well, talking a little bit more detail about trust, this is a great way to protect our kids. When I talk about estate planning being a gift for our family, this is the primary way that we do it. All right, leaving assets to our kids through a trust. If we leave assets through a trust, we avoid probate. We keep them from having to go through that mess with the court. And if anybody listening today has ever been through the probate process, you know what a disaster it is. It's lengthy, cumbersome, expensive, confusing. We can avoid all of that with a trust. And if our kids are under 18, we can choose who that trustee is going to be. And the trustee is the person that's in charge of the trust until our kids are old enough. So they're the ones that are going to approve the disbursements, make sure that the money is used for our kids, but we're not allowing the kids to be able to completely take over and spend all the money they want when they turn 18. All right. It's too much of a burden on an 18, 19, 20-year-old kid to inherit from mom or dad. And all of a sudden, a house is sold and maybe they've got a couple of $1 million. A kid thinks that that's all the money in the world. And without even realizing that they go out on a buying spree and buy everything under the sun and blow through that money, faster than you can blink. A trust prevents that from happening because it creates oversight where our trustee is going to be in charge until the kids are old enough, and the trustee is going to have the right to approve or not approve the disbursements to the kids. Talking specifically about what we call the 2020 hindsight trust. This is a proprietary trust that you won't find anywhere else. It's something that just my firm has. It's designed specifically for complex family structures and blended families. It allows for inclusion of stepkids, half siblings, adopted kids, you name it. All right. Any potential type of blended family out there, the hindsight trust is designed so that we can protect those kids, protect their assets, make sure that those assets don't walk away with, their own divorcing spouses if that were to happen, or their creditors, and make sure that the money is there for the kids that we choose and that it's there where no one else can come in and get at it. It even protects against remarriage complications like what happened with Dave. If I get divorced and then I get remarried and I want to make sure that my new spouse cannot disinherit kids from marriage number one, I can make sure of that through our trust. So we see lots of different common blended family scenarios. We might have children from multiple marriages. We might have minor and adult children at once. That was the case with Dave. He had two kids in their 20s and then the young daughter that was age 3. And obviously they have different types of needs. 20-year-olds, might be in college or they might be out in the world on their own, while a 3-year-old is still home and fully dependent on mom and dad. And again, we see those situations where step kids are unintentionally excluded because of that parentage act that excludes them unless you specifically name them. So if you don't have a plan, probate decides everything. That means that the judge is going to make the decision about who gets what and who is in charge. And very often, the judge or the court doesn't pick the person that we want. They put the wrong people in charge. Even again, if it's ex-spouse, but they're the guardian of the kid, they can be in charge of the kid's money, and that can turn into a mess. And we don't want kids to be disinherited, and we also don't want them to receive too much too soon and have the ability to blow through that money. And again, blink and it's gone. So what we tell people is plan now so that you don't pay later. The idea is to get an estate plan set up so that we know what exactly we want to happen with you and your kids. Make sure that your assets go where you want them to go. Make sure that the person in charge is who you want to be in charge and that your wishes are followed. At the same time, we're protecting those assets for the kids so that creditors and divorcing spouses can't reach in and get at them. And we're preventing them from getting too much money at once while they're too young. So what does this cost? People always ask about the cost of planning, and it's not an easy thing to give a real answer there. It's It's like asking the doctor to give you medicine before they have a chance to examine you. So until I've met you one-on-one and been able to figure out your specific situation, I can't make recommendations about what your specific estate plan should include. So, like a doctor would say, until you tell me where it hurts, I don't know what medicine to give you. And so we do our one-on-one meetings so that you can come in and tell me where it hurts. And from there, I can make recommendations on what type of estate plan is going to work for your family. Just general ballpark. Your plan investment, you should expect to spend around $6,000 or so to get this done and get it done right, get it done by an expert. And again, that's inclusive of the $500 off coupon that everyone that attends the webinar gets. When we look at things, we guarantee that whatever you invest in your estate plan is going to save you at least 5 times your investment in either estate tax savings or protected assets. That number, I will tell you, is very, very low. Most of our clients end up saving 100 times what they spend in protected assets and estate taxes. We do flat fee pricing with no surprise billing. You're aware of all the charges up front. We do one flat rate. Clients that hire us pay 50% up front. They pay the other 50% at signing. And all of our clients at no extra charge get what we call 3-year checkups. And this is something that I'm not aware of any other law firms doing. And this is designed to prevent your estate plan from getting old or going stale. And through our 3-year checkup system, you come in and you sit down with us at a minimum of every 3 years. We can either do a face-to-face meeting or Zoom or by phone, and we go over your plan. We go over what's changed in your lives over that last 3 years, and we go over what's changed in the law because the law can change day by day. And those changes can greatly affect your estate plan. They can make them obsolete. They can even turn it into doing more harm than good if we don't update them. So we need to make sure these things are always updated. We do that through our 3-year checkup program, and those 3-year checkups are free for life. They're included with every single client of ours at no extra charge. So, again, why do a plan? What's planning about? Well, it's about control. It's about love for our kids and making sure that we're giving them that gift of a clean, easy, as simple as possible transition of assets if we pass away. So you can control where your money goes. You can protect all your kids, no matter what family they came from. We can prevent fighting, and we can prevent confusion. So when I talk to parents about this that come in to see me every day, I tell them, hey, you're the hero of this story. You coming in to do this makes you that hero for your kids. And those of you that are in attendance with us today, just by showing up today, caring enough to take the time to listen to the webinar, and hopefully taking the time to actually move forward and take the next step with this and get your planning either done or updated, is a way that you really are the hero to your family and to the kids. I say it around my office all the time, not all heroes wear capes. And the everyday client that comes in to see me to get this stuff done for the kids, they're the real true heroes, and I tell them that. So anybody that is interested in looking to take steps forward and actually get this done or get some old planning reviewed or updated can come in for what we call a strategic planning session. All of our webinar attendees get this session for free. There's normally a $450 charge for this session, but because you attended the webinar, we take care of our webinar attendees, and that fee is waived. During that meeting, we'll review your family structure. We'll identify any red flags, any missed steps in planning that you might have already, and we build a tailored solution. And my job during that session is to come up with a recommendation for a plan that's going to work for you, present you that recommendation with all of the details, the pricing, all of that information up front. And then at that point, it's up to you to decide if that's something that we want to move forward with or if it's not. But at the very least, you get a lot of good information that's going to be helpful to you. I guarantee you're going to get value from that meeting, whether we determine that we're a fit for each other or not. So again, a special offer for our webinar attendees, free consultation that $450 fee is waived. You also get $500 off of your planning, but we have very limited spots for this. So we hold spaces available for our webinar attendees, but the catch is that you need to call the office and book your appointment today, and that appointment needs to be for within 30 days, because after that 30 days runs, everything that we've gone through from the webinar just kind of starts to dissipate because life happens and we forget and we don't remember everything, and we really end up having to start over when you come in for your meeting. But we do it within 30 days while this information is still fresh, and we can really hit the ground running and help you get this done. So again, final thoughts today. We want to make sure that, again, you give your kids and your family this gift. Be the hero to your family. You get one shot to do this right. Look at Dave. He was only in his 50s when he passed away unexpectedly. We all thought that he had another, 40 years of life ahead of him. He had no reason to think that he needed to get his planning done right away. And he passed away unexpectedly before he got a chance to do his planning, and his family, his older kids, paid the price for that. So remember, we're here to help you. We want to help you protect your family. It's something that we do together. I am going to take questions at the end for anybody that's got any questions. You can feel free to type them into the webinar chat. So you can certainly type any questions that you have, and I want to make sure I'll address those. For those of you that have been attending this series of webinars and maybe attended the last one, this has been a series that we've been putting on with different topics. Our next webinar is Wills versus Trusts. Which one is right for me? That's going to be on December 3rd. It's going to be at 12 o'clock. It's going to be a webinar just like this. If you're interested in that, you can scan that QR code to register, or you can give my office a call and we can register you. So again, Wills and Trusts, Wills versus Trusts, which one is right for me? That's going to be noon on December 3rd. Thanks everybody that has attended today. I will make sure we address any questions if they come up. If you are interested in booking that free strategic planning session, you can use the QR code on your screen to do that. But really, the easiest way is to give us a call at the office, 978-657-7437. That way we can get you fit into my calendar. Again, that fee for that strategy session is waived, so the session is no charge, and I guarantee you, you will get value from that meeting. You will get valuable information from me specific to your family. Whether or not we determine that we're a fit to work together, you will leave that meeting with good information. So if you're on the fence, my recommendation to you is to go ahead and get this done. That meeting does include review of any existing documents. So if you've got some older estate planning documents that might be fine, but you're not sure or might need to be updated, you can send us those and I'll review them as well. I really do give them a fair shot, and I'll tell you if they're okay, and I'll tell you if they're not okay. Last but not least, my last ask for folks here, as part of why I do these webinars, this education part, is to try and teach people about this stuff so that they know how to do planning and they know the consequences of not planning. And the way that we do that, the way that we reach the most people, is to just continue to expand our network of clients and followers. One of the ways we do that is by asking folks to leave us a review, leave us a Google review. When folks do their Google searching and they find us and they're considering attending one of our webinars, it's really helpful to have folks that have attended the webinar leave us a review and say, hey, I got valuable information from Mike at the webinar. You don't have to be a client to do that. All you have to do is say, good webinar, good info. And that helps us reach more people. It helps us help more people. So if you're able to do that, you can scan that QR code on your screen and you can leave us a review. You could also go to reviewmlaw.com and you can leave us a review that way. I would really, really appreciate it. It's my biggest ask out of this whole thing, is if you did get some good information today, if you had any of that, aha moment, or realize something new or learn something new, leaving that review would be really super helpful. And again, you can book that free strategy session through that QR code or calling the office. Calling the office really is the easiest way, and my intake team will get you set up. You come in and sit down with me. If you're on the fence and really have been procrastinating about this, like everybody does, and you ready to take these next steps and really get this done for your kids and your family, take advantage of that free session. All right, I'm looking just to see if I see any questions. Don't see any additional questions. So that means I must have covered everything during the presentation. So again, thanks everybody for joining me today. I really appreciate it. Again, I would greatly appreciate it if you'd be willing to leave us a review and just say that you got some good information from me. And take advantage of that free session. Come in and see me. Let me talk to you about your planning. Let me show you where the holes are, if there are any, and let me help you fill those so that you really can leave the gift for your family. Get this done right. Thanks a lot, everybody, for joining me today. I appreciate it. Look forward to speaking to you further.